But before we go back to some of the issues that are surrounding the primaries, several aspirants jostling for the numerous political posts. All eyes will be on the vetting agencies to prove that the elusive adherence to the integrity code among politicians will at least be implemented in the upcoming general elections. From the famous Chapter 6 of the Constitution, aspirants are supposed to pass a tough integrity test, which among others is be honest, not to have abused office or misused public resources. They should also have not falsified records, engaged in unprofessional conduct, or committed a sexual offence or any other crime punishable in the court of law. However, the implementation of this particular ambitious law has largely been in a dilemma to both political parties and vetting agencies, as aspirants argue that the final decision should lie on the voters. Joining me in studio now is constitutional lawyer Peter Wanyama to help us dissect this particular issue. Peter, thank you very much for coming in. The argument is that this should entirely lie on the voters. They should decide whether they want to have a guy who has a criminal record or not. What do you think?
Thank you for having me. The leadership and integrity issue is a very fluid issue. It's a fluid question for the reason that it is the first time in this country that we are trying to enforce some of these issues. Initially, in the previous constitutional order, these principles, these issues never existed in the Constitution. So we are now, for the first time, introduced them in the Constitution. But now the problem, which in my view provides the weakest link, and it will make the work of the enforcement agencies very, very difficult, is that the primary legislation for enforcing the leadership and integrity issues, the moral codes, the ethical concerns, the ethical requirements in the Constitution, the primary legislation, the Leadership and Integrity Act, the Public Officers Ethics Act, these legislation are very, very weak insofar as providing the framework to implement the provisions of Chapter 6. So I don't see, in terms of moving forward, whether the law enforcement agencies, the agencies themselves, which are responsible for the elections, for instance, whether they have the requisite power and legislative mandate to actually enforce this leadership.
So what are we saying? This is a tall order?
In my view, it's an extremely tall order for the reason that, apart from the weaknesses in the legal framework, the enforcement of the legal framework component is a problem as well. We've not seen the IEBC and the other enforcement agencies, including the Ethics and the Anti-Corruption Commission, come up strongly to provide a framework on how they are going to enforce it, these issues. So what we have are principally administrative discretion. So the enforcement is done in a manner which demonstrates some bad excess of discretion, and that is very, very problematic insofar as the legal framework enforcement is concerned. So my recommendation is that perhaps Parliament should again relook at the legal framework, try and tighten the enforcement mechanism. For instance, the principle that it is up to the applicant, because the legal framework contains a very problematic principle that the person who is supposed to be the subject of that enforcement is supposed to do a self-declaration. So how do you expect me to self-declare that I'm corrupt or I meet the test? Secondly, once you've done the self-declaration to IEBC, it's not very, very clear what IEBC will do on that particular form. What happens is that once you've declared in accordance with the provisions of the Constitution and the Leadership and Integrity Act, IEBC will get the form, and we don't know what happens thereafter. So is there a mechanism to follow up to ensure that persons who don't meet the test are then disqualified? That is, to me, the weakest link insofar as the enforcement of the framework is concerned.
No, but we have the multi-agencies at work. You say we have really weak links in terms of enforcing this particular legislation, so to speak, or enforcing Chapter 6 of the Constitution. But we have a multi-agency at work already. What do we expect to get out of this?
You know, the multi-agency's task cannot be complete if the legal framework is not complete. So in my view, I don't expect anything much. For instance, if you look at the powers of these agencies, what can the ethics and anti-corruption do insofar as the leadership and integrity question is concerned? What can the IEBC do insofar as actually taming that issue of having candidates who have certain moral issues or ethical concerns. Myself, I'm not worried about the criminal component. I'm worried about the requirement of morality and ethics. The requirement of morality and ethics, it appears we haven't legislated on it. But for the purposes of enforcing the criminal law component, that we have the law enforcement agencies. And in my view, the legal framework there is a bit strong. Just a question of enforcement. For instance, if you commit murder, you can be arrested and charged with an offense. However, if you have stolen public funds and there is suspicion that you've stolen public funds,
which happens a lot in this
then there is actually no mechanism to ensure if the law enforcement agencies have not done their work to bring you on board. All of us in the public, we suspect that you are actually a person who is stolen public funds. There's no mechanism, tight mechanism to ensure that you're actually bad from running in office. What we expect is that the Independent Electoral and Boundaries Commission is supposed to come up with a proper framework supported by a clear framework which provides guidance. For instance, if you found to have actually failed the integrity test, so what is the commission supposed to do? So in my view, bringing these agencies in one house in the name of multi-agency initiative without the substratum, that is to say the specific legal framework being strong, then we are still skirting in the dark.
Peter, in all this, what is the role of members of the public, and do they know?
Now, in the totality of things, it appears then that it's up to the members of the public then to decide whether a leader meets the requisite leadership and integrity requirements. But we all know, again, our society, unfortunately, we need sociologists perhaps to explain to us what has become of the Kenyan society. Because persons who actually don't meet the test are the ones who eventually elected to parliament. And we ask ourselves as to whether indeed we have fallen as a society, we are at that level where we really can't make decisions based on these issues. So in my view, we need parliament being the agency responsible representing the people of Kenya to come forward and really tell us, is the Leadership and Integrity Act the requisite legal framework that we need to have a better Kenya insofar as the question of morality and ethics in politics and governance is concerned? Those are, to me, the issues which we need to be interrogating. And going forward, my recommendation is that perhaps we need to bring some prestige in the legislation. We need to ensure that the Leadership and Integrity Act, for instance, contains some enforcement mechanism. We need to remove that requirement of self-declaration. And we need to ensure that persons who don't meet the threshold are actually subjected to that enforcement mechanism, which is feasible and can be implemented. And we also minimize the discretion of these agencies.
So this goes back to weaknesses in the Constitution itself?
No, the Constitution provides a skeletal framework. We don't expect the Constitution to provide everything. In fact, if you examine the provisions of Chapter 6, it's expressed clear and unequivocal that Parliament shall create an effective mechanism to implement this chapter. Now, the problem with the mechanism that we have is that it's not effective. Throughout the cycle, you will see that Parliament has not come out very strongly to ensure two things happen. One is that the primary legislation for leadership and integrity is very strong. Secondly, the secondary legislation which have a bearing on leadership and integrity. For instance, the Election Act. The Election Act is a very, very important document insofar as leadership and integrity is concerned. For instance, IEBC, we expect IEBC to have in its power to regulate primaries. It should prescribe certain integrity requirements. However, if you examine what IEBC has done and all that, then you see that their powers are limited. And at the end of the day, they really can't do much. So we don't expect more people. We don't expect people to be barred from running in this setup. I don't really expect much from
So we'll pretty much see all
multi-agency.
the Tom, Dick and Harrys of this world vying for various
so at the end
citizens.
of the day, it's really up to Kenyans then to decide the type of leaders that we need to have in Parliament and also in the executive arm, both at the at the county and the national level.
Well, quickly, this comes at a time when residents from Embakasi Central constituency wrote to this particular multi-agency saying that they want to bar their member of parliament from contesting again with reason that he is a convict and he was found guilty of abuse of office when he was held office of a mayor back in the day. How would this particular agency handle this particular case?
I think that's an issue which is supposed to be handled by two agencies. That is the CID. The CID have a database for all persons who have criminal records. So we expect that such a leader then is not given the certificate of good conduct by the CID. Of course, there are certain constitutional requirements that he must have filed an appeal. If he didn't file an appeal on that conviction, then we don't expect CID to clear him. Secondly, then the IEBC, in collaboration with the CID, shall not accept such person's papers. So, but now, if the CID and the IEBC clear such a person, then clearly you can see that, and from the look of things, I have seen it, where someone can walk to CID headquarters, you have a criminal record. However, if you pay some money, your records are deleted from the system. Again, at IEBC level, the returning officer, who is responsible for the election, they have certain powers which sometimes they don't exercise these powers properly. So we really expect IEBC and the CID to do the right thing, because they are the ones, if you go to court, the court will tell you go to CID, go to IEBC. So if the people of Embakasi want to be helped, let them take up this initiative with these law enforcement agencies and IEBC to ensure that the person is actually bad. Otherwise, then they will be forced to have such a person as a candidate and then exercise their powers.
All right, in totality, we will be unable as a country to implement Chapter 6 of the Constitution.
Yeah, the implementation of Chapter 6 of the Constitution requires policy, administrative, and proper and conceptually satisfying legal framework.
Which we don't have.
Which we don't have.
Okay. Thank you very much, Peter, for coming in.
Thank
Peter
you very much. I
Wanyama
appreciate
is a constitutional lawyer. There you have it. Of course, as this multi-agency is put together to try and bar leaders who are vying for various positions if they have criminal records or they have there is proof that they abused office, among other crimes that they have committed. But of course, we will be following up on this to see whether the multi-agency will make headway in this. Still at the coast,